Yes, we can hear you very clearly and see you well as well. So
good. The first thing I want to say to you that the experiences that you're having in the UK with the HMRC are near identical to what we've experienced in Australia over at least the last 20 years. It's a very, very similar story. What I'll do in my 10 minutes is present you a solution, in inverted commas. Dave will do some refocusing on the specifics of the HMRC problems, and Jason will give you an independent view of the solution that we've put together based on the IRS in the USA, and he's able to talk to you as MP to MP, has looked at this quite independently from me. We've provided you a one-pager snapshot of the solution and also provided you a 22-page, sorry so long, which provides you a good level of detail. So we've backed the one-pager up with some detail. Just a brief background on myself. I'm a self-employed person, have been for 40 years. I've been an advocate for self-employed small business people for 25 plus years. It's a love job and it's a passion. It's something that I'm very, very keen on and have pursued very strongly. The issue of tax laws in Australia really came to a head in 2000 with very substantial reforms to the administration of tax, and particularly withholding tax in Australia. We had the introduction of our GST and your VAT. But along with that went our personal services income tax laws, which are exactly the same issue as your IR35. Now, I became very aware of IR35 in and around that period. I've been to the UK now, I think 4 or 5 times, and on each occasion in London, I've been very heavily involved in talking to people around IR35, and it's very, very similar to the personal services income tax laws, although I've got to say for a variety of reasons, our issues around the IR type laws in Australia are much better than in the UK. I won't say it's some sort of nirvana, but it is better. But we still have significant problems with the ATO, which are very, very similar to all of the things that I know about the UK with the HMRC. And just as an example, in 2018, I was heavily involved with our Australian Broadcasting Commission when they produced a Four Corners program, and Four Corners is the equivalent of your panorama type exposés. And there was an exposure in that program of the behaviours of the ATO and the abuse of the Australian Taxation Office of small business taxpayers in particular. Then moving on to 2019, and I'm always one in the advocacy game of believing that you not only need to describe a problem, but you need to present solutions and give the parliaments a capacity to be able to look at a solution. And looking around for solutions, my attention was brought to the Taxpayers First Act, which was passed in the United States in 2019. And when I looked at this, I went, goodness gracious, what's going on here? I then got myself over to Washington, DC. I spent quite some time in Washington, DC, and discovered something that quite amazed me, that the US had addressed the problems of the misbehaviour and the unfair treatment of taxpayers by the IRS, that they had addressed this back in 1998. Now, when I was in Washington, I then did a deep dive into this. Essentially, to understand what they did in the United States in 1998, it's an issue about the process of the law. It's about applying tax law and ensuring that it's applied in a fair way within the broad concepts of the rule of law. And this involves a process of accountability and checks and balances against the tax authority. It's very similar to, and the sorts of things that are going on in Australia, and I see in the United Kingdom, the problem really is very parallel to very old-fashioned policing, where the police will know someone's done it, we can't prove it, but we'll take them out the back and we'll beat them up a little bit until they confess. And we know that if the police are not held accountable and there are checks and balances, that's the behaviour that we will get. Now, with the tax authorities, certainly from what I've seen in the UK and in Australia, is that it's an old-fashioned policing problem. They raise tax from taxpayers via intimidation rather than the facts of the case. Now, in the United States, they had exactly the same problems which they saw during the 1980s and during the 1990s and decided to do something about it. And at the very heart of their philosophy and the law in the US now is the taxpayer's right to fair treatment. That overrides the administration of the tax system. And they now have 25 years of experience of doing this. And I can tell you from all of my observations and what I saw and what I studied, it works. It's very, very impressive. Importantly, it's also to understand that the law that was passed in 1998, the reviews that have occurred during that period of time, and then the updating in 2019 with the Taxpayers First Act, this enjoyed absolute and total cross-party political support. So the Democrats and the Republicans all behind this completely. To give you an overview of what they did in the United States, and my view is that this is a reform template for both Australia and for the UK. This is not something, of course, that you just plonk holus bolus, because there are different institutions, different cultures, etc. So there are modifications absolutely required, but the basics of it is very, very sound. So it starts off in 1998 in the United States with what is there is the Taxpayer Bill of Rights. Now, that Bill of Rights is a statement of principles of what people are entitled to. I've included in the longer paper for you, which is Appendix B on page 14, the complete Taxpayer Bill of Rights. It's effectively one page. There are 10 of them. And so the Taxpayer Bill of Rights has things such as the right to pay the correct amount of tax. Pretty simple. The right to finality. In other words, that taxpayers have a right to have their issues settled and settled in a reasonable period of time and not drag on. So these are so there are 10 of these, and we've supplied those to you. The Taxpayer Bill of Rights is then backed up with what they call the Taxpayer Code. Now, in my paper I picked out, or in the longer paper here, I've shown a number of those, but from recollection, there are about 74 of them in the taxpayer in the US. And I've included a number of those in Appendix C on the paper that I've supplied you. So, for example, the Taxpayer Code gets the Bill of Rights, the principle of the Taxpayer Bill of Rights, and expresses those in very practical ways. And I'll give you some of the examples. So the IRS, for example, has the burden of proof. Terribly important. The IRS, for example, can only charge the same amount of interest on a debt as the interest rate that the government pays. If the IRS is selling someone's principal place of residence, the IRS is required to get an independent valuation of the residence, and then are not allowed to sell the residence for under 80% of the valuation. There is a stipulated internals appeals process, and the procedures are laid out. Now, when you go through each of these, and there's quite a long list of them, they are incredibly practical. It's practical administrative requirements imposed on the IRS in terms of how they are to treat the taxpayers. Then the third critical leg to this is the taxpayer advocate. The taxpayer advocate is a division of the IRS, but independent of the IRS. It has complete and total access to all IRS records, doesn't have to ask for them. And its task, and there is a taxpayer advocate, and by legislation, the taxpayer advocate has to have an office in every state in the United States. The taxpayer advocate's role is to check that the IRS is complying with the Taxpayer Bill of Rights and complying with the Taxpayer Code. The taxpayer advocate, under legislation, has a set percentage of the IRS budget allocated to it. I think from recollection, it's about 3%. The taxpayer advocate is also able to make taxpayer orders. So they can make an order against the IRS to do something or to stop doing something. Now, the IRS is not required to comply, but if they don't comply, they have to report to Congress on those matters on which they have not complied, and they have to explain why. Now, mostly my understanding is that these taxpayer orders, there are probably only 3 or 4 a year that the IRS doesn't comply with. The critical thing with all of this is legislated. It's not policy. It's not something sitting off to the side. The critical thing and the most important thing is this is legislated. My view is that this is a template for reform of the Australian Taxation Office, and I suggest for reform of the HMRC. It's an integrated package, and I can repeat, it must be legislated. The examples in the paper we've put together hopefully gives you a starting point. And one of the things I've learned in doing advocacy is that in presenting a solution, it's really just a bouncing off point, because there will be lots of issues that you have and you have in the UK, which I don't necessarily understand, but it gives you a starting point. What we have done in the paper also is done what they did in the US, and we've had a look at the HMRC's, what they call their litigation and settlement strategy. I've included that as item 6 on page 9 and pulled out a number of the things there. In other words, the litigation settlement strategy is what the HMRC say is the processes that they follow. And my view and the experience of what I've seen is that on very many occasions, quite repeatedly, they do not follow those. And as a starting point in this exercise, there's no reason why those litigation and settlement strategy couldn't be put into legislation. If this is what the HMRC say they do, well, what's wrong with legislating it? And I've made a series of examples of how that could, the principles of how that could be applied. My view is that Dave has described to me the APPG and what you're on about and how many members of Parliament are in the committee. My view is that you have probably got a unique opportunity to do something here. Very much like in the Congress in the United States, it's the Congress people who drive the legislation. With the likes of the APPG, with your committee, your group, you could probably drive this. And we would certainly be available to assist if you chose to go down that sort of path. Done.